Discovery should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen, not play word games with me. You're playing with the wrong judge.
I'm not trying.
I'm giving you your warning.
I would like to first have a jurisdiction hearing.
So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong.
Today's courtroom drama took an unexpected turn as a self-proclaimed sovereign citizen clashed with a presiding judge in a fiery exchange that quickly escalated. What started as a routine hearing soon became a spectacle of defiance and legal confusion. For those unfamiliar, sovereign citizens are individuals who believe they can exempt themselves from government laws and regulations, often citing obscure interpretations of legal texts. In this case, the defendant attempted to challenge the court's authority, insisting that standard legal procedures didn't apply to him. The judge, maintaining composure and professionalism, responded firmly to the disruptions. Despite repeated warnings, the defendant continued to interrupt proceedings, leading to a swift and decisive outcome that reinforced the rule of law. This hearing was anything but ordinary. It was a whirlwind of legal jargon, bold claims, and courtroom tension. Viewers might find themselves glued to the screen, captivated by the unfolding drama and the judge's unwavering stance. We'd love to hear your thoughts on this unusual legal showdown. Was justice served? Did the court handle it well? Share your views in the comments below. And if you enjoy insightful breakdowns of real-life legal moments, be sure to follow for more updates. Let's unpack the details together.
Already, Judge Torshio Feaster, Assistant Public Defender, on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
Is this going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had another counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here, so I don't know what's going on, Your Honor.
No,
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh.
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're going to do. Then I'm going to say, okay, you've got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're going to represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay, and at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See you
didn't
at 3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
Spoiler alert. The defendant arrived at 3 p.m., despite previously stating he'd show up at 3:30. That discrepancy didn't go unnoticed, and it quickly became a focal point in the hearing. The individual in question appeared to understand the court's authority over him, yet his actions told a different story. By misrepresenting his arrival time, he inadvertently confirmed the very jurisdiction he was attempting to challenge. Moments later, the judge addressed the situation head-on. In the legal world, Misleading the court is a serious offense known as contempt. It's not just frowned upon, it can lead to fines, penalties, or even jail time depending on the severity. This wasn't just a minor scheduling issue. The courtroom operates on precision and integrity, and any attempt to bend the truth disrupts the entire process. The judge's response was swift, stern, and a clear reminder that honesty is non-negotiable in legal proceedings. Ultimately, the defendant's strategy backfired. What may have seemed like a clever move turned into a cautionary tale about the consequences of playing games in a courtroom setting. Time was wasted, patience was tested, and the lesson was loud and clear. What's your take on this courtroom moment? Was it a bold move or a miscalculated risk? Share your thoughts below, and if you enjoy breakdowns of real-life legal drama, stay tuned for more updates and analysis.
Indicated that you wish to represent yourself on this matter.
Yes.
All right. You understand at your arraignment you were given the charges that were have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was fleeing and eluding.
Fleeing and eluding third degree.
Third degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
First, I wanted like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing, and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser, with the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
Let's unpack a moment that left the courtroom buzzing. The defendant, already under scrutiny for misleading the court about his COVID status, entered the courtroom without a mask and immediately challenged the court's authority. He insisted the case be thrown out, claiming there was no injured party involved. This line of reasoning is often used by individuals who subscribe to fringe legal theories, suggesting that unless someone is physically harmed, the court has no grounds to proceed. But here's the reality. Jurisdiction isn't determined by personal belief, it's established by law. And showing up in court is a strong indicator that the court does, in fact, have jurisdiction over you. As for the no injured party argument, it doesn't hold water in cases involving public safety violations. Charges like fleeing and eluding law enforcement don't require a direct victim. They're prosecuted because they endanger the public and undermine legal authority. The defendant's approach resembled more of a theatrical protest than a legal defense. His arguments lacked foundation, and the judge wasn't having it. The courtroom is a place for facts, not fantasy, and this individual's strategy was quickly dismantled by the rule of law. This hearing serves as a reminder. Challenging the system without understanding it rarely ends well. Let's head back into the proceedings and see how the judge handles the rest of this unconventional defense.
Finish.
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust, and I'll be able to supply you all with the adequate assurance certificate of security to settle and offset the charges.
Okay. Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing.
This is a probable cause hearing.
So I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was.
You weren't able to do what?
Provide my exhibits
To whom?
to the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not this time.
All right. So how would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done that.
Is anyone else starting to feel a twinge of sympathy for this defendant? Because what's unfolding in Judge Simpson's courtroom is nothing short of a legal meltdown. The judge, clearly fed up with the antics of self-proclaimed sovereign citizens, isn't holding back, and the tension is palpable. The defendant seems to believe he's attending a casual pretrial discussion, but this is the real deal. He's tossing around legal terms without understanding their weight, and it's painfully obvious he's outmatched. His arguments are scattered, his logic is shaky, and his grasp of courtroom procedure is nearly non-existent. One of the most baffling moments. He insists on presenting evidence for a hearing that doesn't require it. It's a fundamental misunderstanding of how the legal process works. And instead of seeking help, like the free legal aid that's readily available, he's choosing to go solo, battling seasoned professionals with little more than misplaced confidence. Judge Simpson, known for his no-nonsense approach, is visibly done with the theatrics. His responses are sharp, his patience thin, and his message clear. The courtroom is not a stage for pseudo-legal performances. This isn't just a clash of personalities, it's a cautionary tale about the importance of preparation, humility, and knowing when to ask for help. The defendant's strategy, if you can call it that, is unraveling fast. What's your take on this courtroom showdown? Is this defiance or delusion? Let's head back in and see how the rest unfolds.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer.
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not. They are not.
No need to.
They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my motion.
Do you wish this set for preliminary examination? Your motions have been
I
denied.
wish for the prosecution to provide the evidence that any of this needs.
You don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery
discovery?
should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery.
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
Let's break down a moment that left both the courtroom and viewers scratching their heads. The defendant, already facing serious charges, suddenly requested a jurisdiction hearing long after the case was underway. It's a move that raised eyebrows and revealed a fundamental misunderstanding of how legal proceedings work. A jurisdiction hearing is typically held at the very start of a case, before any arguments or evidence are presented. It's the moment when a defendant can challenge whether the court has the legal authority to hear the matter. But once you've entered the courtroom, sat before the judge, and the case is officially in motion, that ship has sailed. The defendant's timing was off, and his reasoning unclear. Was this a genuine legal strategy, or something he picked up from an online forum? Either way, the court had already established its jurisdiction. His physical presence at 3 p.m. was proof enough. You can't simply declare the court powerless and expect the case to vanish. This situation highlights the importance of understanding legal procedures and seeking proper counsel. Free legal aid exists for a reason, and relying on vague internet advice or personal theories rarely ends well in a courtroom setting. So what do you make of this legal detour? Was it a bold attempt or a misinformed misstep? Let's head back into the hearing and see how the judge responds to this unexpected twist.
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threat and duress of coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter, in regards to the name as well as the vessel that was used, is again under. It was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly properly functioning at this time. So with that.
All right. So here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong, because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the State of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So that would be the next step, and I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine, and then I will file the proper documents for the jurisdictional hearing. Gotcha.
So I'll adjourn the probable cause conference in this case. April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable
setting the date
So
of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PCC, to a preliminary examination.
Just for the record, I put it on the record that I object. But under threat, duress, or coercion, again,
Your objection is noted.
right, and under threat and duress and coercion, I'll be here.
Is there anything else?
I said what I need to say.
Anything else from the people?
No, Your Honor. Thank you.
Bond will continue.
Am I waiting for paperwork or I get it from the front?
Pardon?
Am I waiting for paperwork regarding the next?
So you may leave.
Oh, is it being mailed? I'm trying to figure out how to get the paper.
You can check out at the front desk.
Okay, thanks.
Let's talk about what just unfolded in Judge Simpson's courtroom. The defendant, identifying as a sovereign citizen, walked in with a bold attitude and a shaky grasp of legal reality. From the moment proceedings began, it was clear he wasn't there to cooperate. He was there to challenge authority. Now, some viewers might wonder, was Judge Simpson too firm in his response? It's a fair question. But when you look at the facts, the judge's tone wasn't about rudeness, it was about restoring order. The defendant came in treating the hearing like a debate club, tossing around legal buzzwords and demanding dismissals based on theories that simply don't apply. Sovereign citizen ideology has gained traction online, often fueled by misinformation and promises of loopholes that don't exist. These individuals believe they can sidestep legal consequences by rejecting the court's authority. But in reality, showing up in court already confirms that the system has jurisdiction over you. Judge Simpson didn't just push back, he delivered a necessary dose of truth. His response wasn't personal, it was procedural. And maybe, just maybe, this moment will encourage the defendant to seek proper legal counsel next time. Free legal aid exists for a reason, and ignoring it only leads to confusion and wasted time. This trend of courtroom defiance is growing, and it's costing taxpayers time, resources, and patience. The legal system is built on structure and respect, and when that's ignored, consequences follow. Perhaps if more judges responded with the same clarity and firmness, we'd see fewer of these misguided challenges. So what's your take? Was Judge Simpson enforcing the law or crossing a line? Drop your thoughts below. I always enjoy hearing your perspectives. And if you appreciate thoughtful breakdowns of real-life legal moments, don't forget to follow for more. Thanks for tuning in, and stay sharp out there.